If somebody accidentally or recklessly damages your car in a car park, causing £1,500 worth of damage, don't count on the DVLA giving you the details of the registered keeper of the vehicle to try to determine who was driving the vehicle at the time so that you can chase them for civil liability. But if you're parking badly, however, they probably will. Let's talk about this. Welcome back to the channel. So as always on my channel, I will admit when something doesn't quite go to plan. So here I am to tell you that something didn't quite go to plan. Because you may remember I did a video previously where somebody did cause about £1,500 worth of damage to my vehicle by being careless because they brushed against it with a bag with a zip on it, causing damage. Not only were the police not interested because they didn't believe that it could be a criminal offence because they couldn't really be sure that they would get a conviction on it, even though being reckless as to causing damage is still criminal damage, but they weren't interested in pursuing it. Now, I'm not a specialist criminal barrister. I've done some criminal work, but I'm not a specialist. So other criminal barristers may tell me that that's probably right and that they probably wouldn't get a conviction on someone being careless, brushing up against my car with a bag with a zip on it, causing £1,500 worth of damage. I'll stand to be corrected. I think that's reasonable to pursue that, but they obviously didn't. But criminal liability aside, one might at least think that civil liability is certainly justified. Now, I am a civil practitioner, and I would be reasonably confident taking this to court with the person responsible that they were careless enough to have caused such a lot of damage and expensive damage to the vehicle that they should be held at least civilly liable to pay for that damage. Now, where do you start in obtaining those details? Well, you have to go to the DVLA. Now, just as a caveat to all this, the DVLA have the power, rather than a duty, it's been held in court, to provide the details to anybody that has either a statutory or a reasonable cause to request those details. Now, this is the point at which the DVLA contradict themselves. So allow me to take you to a document that proves that the DVLA contradict themselves. Moving first of all to the DVLA's own guidance. This is a guidance document for the release of registered keepers' details. This is a guidance for anybody that is interested in looking at it. It is the release of information from the DVLA registers. It sets out when, how, and why the DVLA will choose to release these details to you. Now, ordinarily, obviously, it will be released to police, other people such as, road traffic enforcement, collecting tax, and all of these kind of reasons. However, their own guidance also says, and I quote, that these details may be disclosed to law enforcement authorities, private litigants, and organizations as a first point of contact to establish where liability for an incident or event may lie. Now, this gets even more particular in just a moment, but let's just break this down into very simple terms. The DVLA will release these details of the registered keeper to law enforcement authorities, obviously the police or HMRC or the Serious Fraud Office or anything else. Now, organizations that might cover private parking companies. So if you are parking badly, either so that you'll be liable for a penalty charge notice, that's the official sort of fine kind, or a parking charge notice, which is the private invoice type kind where they might send you a bill for alleging you to be in breach of contract. I've done a video on that just recently as well. And by the way, if you are in any of those situations, I will take this opportunity to plug our app Proofify, which is an app that allows you to store evidence in case you ever need it in the future. It will create a contemporaneous record of evidence that you can produce in court, time and date stamped, and all of that sort of stuff. I'll link that in the description below. Go and check that out because you might need to prove your case in court at some point someday. Back to the point. Organizations might be private parking companies. Now, you could be sure that the DVLA is going to release your details to them because more often than not, that's going to be the case. Private litigants. So just to reiterate, this is the DVLA's own guidance. These details, the registered keeper's details, may be disclosed to private litigants as a first point of contact to establish where liability for an incident or event may lie. It doesn't say road traffic collision or anything like that, just an event. Something happened. So just as a brief tangent to explain what event means in the eyes of the law, if you have an insurance claim, there must be an event. So your wall falling down is not really an event. It might fall down due to wear and tear, age, and all the rest of it. If your wall falls down and injures somebody or smashes up some property, that's an event. Something's happened. And if someone crashes into it, that's an event. Something happened. So an event is just something happened. Something must happen for insurance to kick in. So in this situation, something happened. The vehicle was damaged. Somebody brushed against it and caused a lot of damage. So an event happened. So in my view, this would be the perfect place, as in the registered keeper of the vehicle, should be the perfect first point of contact to establish who was it? Was it the registered keeper? Or who was the driver? Who was the driver responsible at that moment in time to be liable for the damage caused to the vehicle? So my reading, as a lawyer, my reading of the DVLA's guidance here, the details may be disclosed to a private litigant as the first point of contact to establish where the liability for an incident or event may lie. Disclosure in these circumstances does not breach the Data Protection Act, and the Information Commission Office is fully aware that data held on the DVLA's records is released in this way, which incidentally, by the way, as a reminder, this applies to parking companies as well. It doesn't breach the Data Protection Act. A lot of people think it does. It doesn't. Now, the important bit is this bit here. Reasonable cause for the data release. Reasonable cause for the release of data from the DVLA registered vehicle relates to motoring incidents with driver or keeper liability. That's very important for a moment. For a bit in a moment, where I will show that the DVLA essentially contradicts itself and goes against its own guidance. Driver or keeper liability. So it could be the keeper that's responsible. It could be the driver that's responsible. It's just reasonable cause. And reasonable cause is an objective. You know, would an ordinary, reasonable, honest person think that, yeah, that's a good reason to release these details of either the keeper liability or the driver liability? Remember, as a first point of contact to establish where that liability is. So the registered keeper, just for argument's sake, I will explain, is the person who is registered with the DVLA as being overall responsible for that vehicle. But the release of information is reasonable cause in respect of the driver or the keeper liability. Okay, so it doesn't have to be the registered keeper. That's the DVLA's own guidance, because I did have one or two comments about that on the previous video. These can include road safety matters, events occurring as a result of vehicle use, i.e. you park it somewhere, get out and smash up the car next to you. That's a result of the use of a vehicle, because you parked it somewhere. You've got out and you've damaged the vehicle next to you. That is, on any objective assessment, as a result of a vehicle use. Because if you didn't use the vehicle, it wouldn't have happened. But for the use of the vehicle, you wouldn't have got out of the vehicle and damaged the car next to you. Okay, so enforcing road traffic legislation, of course. Collecting tax, of course. In all data release matters, we act responsibly and in accordance with the law. I should hope so. Where reasonable cause has been shown, we disclose information on the condition that it will only be used for the requested purpose and that the recipient will protect its confidentiality. Of course, you can't just get that information then splatter it across the internet. Of course, no one should do that, and I would certainly never intend to do that. In fact, when I've written to the DVLA, I have said, I make absolutely clear that I will only be using the details for that purpose. I've done it a number of times. I've done it for my own personal uses, and I've done it for clients. I've written as a lawyer to the DVLA to say, my client needs this information for XYZ purposes. Rest assured, it will only be used for the litigation. The law allows us to charge a fee, yada, yada. Okay, so long story short is where reasonable cause is shown, the DVLA, by its own guidance, should release details to private litigants as the first point of contact to establish where the liability lies, whether it is the keeper or the driver responsible for an event, which could be anything which as a result of vehicle use, such as parking it and getting it out and damage the car next to you. However, this is where it gets interesting. The DVLA, I will switch to an enlarge so you can read it. This is a snippet from a letter from the DVLA. We normally decline providing information where the inquirer's aim is to identify a person through the registration mark of the vehicle. But that's contradictory in itself. Because the whole purpose of the release of the information is to find a first point of contact to establish where liability is. The details may be disclosed as a first point of contact. That's the whole point. So to decline, normally decline, it said, where the inquirer's aim is to identify the person. That's the whole point of disclosing the details. So that's contradictory in itself, but that's not the main one here. The main one is the bit that I've highlighted. There is no guarantee, and this is the reason that the DVLA gave for declining those details. There is no guarantee that a registered keeper is in charge of the vehicle at the time of the offence. Well, of course, no one's asking the DVLA for a guarantee. No one is providing a guarantee to the DVLA. Remember, the DVLA's own guidance doesn't say anything about a guarantee. It says a first point of contact to establish where liability for an incident may lie. And so this is talking about private litigants. You or me, not me as a lawyer, but you or me as an individual who wishes to sue whoever it was responsible, which is not necessarily the registered keeper of the vehicle, but the only way to establish who was driving the vehicle at the time is to contact the registered keeper, because the driver is certainly not going to have their details registered with the DVLA against the vehicle. That's not the point. The point is that the registered keeper is registered with the DVLA, and it's their details that the DVLA could release to establish who the driver was at the material time. However, the DVLA contradicts its own guidance by saying there's no guarantee that a registered keeper is in charge of the vehicle at the time of the offence. Now, first of all, it doesn't matter whether it's an offence or not. It could well be an offence if you would take the literal meaning of the law. As I said, I am not a criminal specialist, so I may get a whole group of criminal specialist barristers say, yeah, no chance, mate. That's not going to happen. But on a technical reading of the definition of criminal damage, if someone is reckless so as to cause damage to someone else's property, it's criminal damage. So reckless is simply recognizing that the risk exists and carrying on anyway. So, for example, if you're walking between two cars carrying a plank of wood and it scratches the car, any reasonable person would have recognized the risk of damaging the car walking between vehicles with a plank of wood and did it anyway and damaged the vehicle. So that's the point here. That on a technical reading, that would satisfy criminal damage. But I can understand why police might say, look, this is not going to hold up a prosecution. And other criminal barristers probably tell me the same thing. But that's not the point. On a civil standard, I'm reasonably confident that a court would say, well, yes, there was a clear duty between road users to not damage each other's vehicles, and the person was careless. It's proven pretty much beyond any doubt that this person caused the damage, because there are contemporaneous photographs taken by the vehicle precisely lining up the contact between the person and the vehicle and the damage on the car, and therefore a court is going to find, in my view, a court is going to find that that person caused that damage to the vehicle. So on a civil standard, they were reckless, they caused the damage, they should pay up. So the only way to find out who that was, according to the DVLA's own guidance, or supported by the DVLA's own guidance, is as a private litigant to establish as a first point of contact with the registered keeper of the vehicle, who it was driving at the time, which, let's face it, it probably was the registered keeper. It was a nearly new vehicle. So it probably was the registered keeper. It may not have been, but it probably was. It wasn't. It didn't appear to be a rental vehicle or anything like that. It could have been, but it probably wasn't. It was probably the registered keeper. But even if it wasn't, as the DVLA guidance itself says, it's the best first point of contact to establish who was responsible for the incident. But just in case you were wondering about the parking and everything else, let's move to this screen here, which is the Road Vehicles Registration Licensing Regulations 2002, which provides for the disclosure of registration and licensing details. And you can see here that these details may be released by the local authority for any purpose connected with the investigation of an offence or of a decriminalised parking contravention by the chief of police, and so on and so on. Or, and this is the point that allows any private litigant to obtain those details, by any person who can show to the satisfaction of the Secretary of State, i.e. the DVLA in this instance, that he has reasonable cause for wanting the particulars made available to him. So, in my respectful view, I think the DVLA get this wrong and contradict their own guidance, because a reasonable cause, surely someone saying this person, this driver caused £1,500 worth of damage thereabouts to a vehicle by being careless as they got out of the vehicle, surely that is reasonable cause for wanting to find out who that driver was. And the only way of doing that is to contact the register keeper of the vehicle by saying, whoever was driving the vehicle on this material date and time damaged my car. Who was it? Was it you? Or can you tell me who it was? And then you can pursue them for the costs of repairing the vehicle. Because otherwise, whoever it is, and whether the vehicle is an expensive one or a cheap one, it matters not. If someone's damaged your vehicle, they should be paying for the repair for the damage. And the only way to do that, and backed up by the DVLA's guidance, is to find out, as a first point of contact, who it was. Now, many of you in the comments might start to say, well, you're overreacting, this is all, over the top, and the DVLA is right, and you shouldn't have the details. But if you're in that camp, I respect your view for one, but I would say to you, if it were you that had your vehicle damaged like that, and you had clear evidence of the person doing it, an unequivocal photograph, video evidence of the person damaging that vehicle, and the law provides a mechanism to find out who it was, and you get someone stand in your way and say, no, I'm not going to show you the details, because, as it said in the letter, there is no guarantee that the register keeper is in charge of the vehicle. But that's not what the law says. The law says any reasonable cause for wanting the particulars. Now, reasonable cause is not defined in law, because it's one of these things that shouldn't really need to be defined, because reasonable is just what an ordinary reasonable person would think. Is it reasonable to want the details of the person that can tell you who was driving the vehicle at the time that damaged your vehicle? Yes, is the simple answer to that. I think that's reasonable. Let me know in the comments what you think. Do you think that's reasonable? I think that's reasonable. It's certainly reasonable when they want to pursue whoever it was that was parking badly for a fine or for a parking charge notice. They certainly think it's reasonable then, even though there's no guarantee that it was the register keeper of the vehicle that was parking badly at the time. They will still give the details of who was the register keeper of the vehicle. Not least of which, because there are other regulations, which I'm not going to go into in this video, that make the register keeper ultimately liable, whether they were driving or not. So if the vehicle was parked on WLA lines or whatever, they will go after the register keeper of the vehicle, even if it wasn't the register keeper of the vehicle that was driving at the time. They can nominate someone else and say it was them. But if they don't do that, or they don't know or whatever, they will go after the register keeper of the vehicle because they think that's reasonable. So once again, if I haven't laboured the point enough, DVLA believes that a private litigant should be released the details for a first point of contact to establish who is responsible if they show reasonable cause, as provided in the legislation. And I think reasonable cause, as I've said, is very much satisfied here. But long story short, don't count on the DVLA. I've said in previous videos that you can file these forms with the DVLA and you should be able to obtain the details because that's reasonable. An ordinary objective view would be that you should be able to get those details. But no. If you come back to your car and there's a big scratch down the side and your vehicle has caught who's doing it, unless they did it absolutely deliberately and the police are interested in prosecuting it as an offence, don't count on finding the details. That scratch is yours to sort out. So I know that probably wasn't entirely nice to hear if that you're in that position. If you're parking badly, they will give the details, but if your vehicle's damaged, they probably won't, unless it's proven either there's a guarantee that the person was the register keeper, which there won't be, or the police are interested in doing it and getting the details for you. So, like I say, let me know what you think in the comments below. I, for one, think that would be a reasonable request. They don't, so I stand corrected. I'm big enough to correct when I say that should happen, and it doesn't happen. The reality is, don't count on the DVLA. Don't count on the DVLA following their own guidance. That's my conclusion, based on all those facts. My view. So, with that said, please do like the video and subscribe to the channel, and I thank you for watching.